Hello everyone. Welcome to the webinar on the 10 blunder mistake that every startup should avoid. Today with us, Mr. Hemant Kelkar sir is here, founder of Startup Legal, and he Startup Legal is also associated with AIC Pinnacle as a legal partner. They also help us to our startups to solve their legal problems with our all AIC Pinnacle startups. So, Hemant sir, welcome you. And I would like to also just little bit to start with our AIC Pinnacle. AIC Pinnacle is the Section 8 not for profit incubator, which is supported by 4 different government ministries. Uh, for more details, you guys can visit our website www.aic-pinnacle.org. Hemant sir, please start with your introduction and hold the topic we have decided today. Please, over to you.
So thanks a lot, Uday bhai, for inviting me to this session. And thanks to AIC Pinnacle, first of all, for organizing such sessions, which help startups, especially early stage startups, in overcoming difficulties which are very typical at that early stage, when they have limited resources to go forward. Timely guidance through superb institutions like AIC Pinnacle are a great support to the startup ecosystem. So thanks a lot once again for first in organizing this kind of a session, and then inviting us to be a part of it. We are happy to contribute in any small way that we can over here. So having said that, first of all, I'm very happy to see we have 26 participants for this session. I was under the impression, or should I say misconception, that startups do not pay a lot of attention towards legal aspects of their business. But I'm clearly wrong. I mean, if 24 and the number is increasing, we are 30 now. So if so many startup founders are being proactive in taking care of legal aspects also, it's a very happy situation to be in. And so what are the coming to the topic at hand, what are the typical mistakes which early stage startups make, which can land them in trouble, and we are talking purely from a legal perspective. Obviously, the path of a startup from its conception, ideation to its maturity is a minefield, and one of the traps on which startups can step is that of a legal non-compliance, or legal not being aware of legal requirements. And that is what we are here for. We are here to help you avoid those mistakes, so that obviously, I mean, prevention is better than cure. So that's the whole point. So what I'll do is I've prepared a short presentation. Don't worry about noting anything down. I will share it later with Uday bhai, and he can share it with you guys later on. I will, through our own experience consulting, lots of startups, will share whatever we have learned about these typical early stage mistakes, right? So I'll just share the screen now. Yes, is this visible to everybody?
Yes, yes, sir.
All right. So so see, I mean, we'll go stage wise. So what is the first stage, when the startup is at an idea stage, what we typically call an ideation phase, where prospective co-founders come together and start brainstorming on various ideas for their startup. Uh, these co-founders come from various walks of life. They may or may not be related to each other. They may or may not be a part of the same family. More often than not, they are not part of the same family. and which is why a founders agreement is an extremely crucial document which every startup founder must execute, uh, and not having a founders agreement is can have very bad consequences. So how I'll tell you, all the examples, all these points that we will discuss, I will give you examples that we ourselves have encountered in our during our consultancy to various startups. So in one of the startups that we encountered, what happened was that they were at a slightly advanced stage, okay, and where they were now at a stage where they were going to go for a fundraise. Okay, they had reached that stage, and at that very stage uh, there was a large sort of disagreement between the founders regarding one of the founders wanted to exit before that, and he wanted certain remuneration in lieu. So there was no founders agreement at that time, and there was also no shareholders agreement which they had executed between them. So there was, it was just their MOA and AOA, which was just a standard templatized formats that they had used from the MCA website. So there was really no specific provision for how the exit of a particular founder is going to take place. Okay. Because of that, what happened was that there was this dispute between the founders. One of the founders just left the organization, and he had a 49% shareholding in that startup. Okay. So it was around a year and a half since they were incorporated, and things were going well. Till they were going well, it was okay. But the moment there was this disagreement between the founders, as to one of the founders, he wanted to exit and move somewhere else. And because there was no agreement, there was no prior understanding between the founders on how he was going to exit, on what conditions, how were the shares that he already had, how were they going to be treated in such a case. Uh, he simply walked out, and he refused to surrender the 49% shares that he had, right? So that and imagine the situation for the other remaining founder who had only 51%, and there were just two founders. They were only the directors, they were only the shareholders. So one of the founders had 51%, the other had a 49% shareholding, right? This 49% guy, he simply walked away, and now the 51% guy was stuck uh, on how to move forward. In the end, he had to negotiate with the exiting founder and pay him a handsome amount in exchange for for him to surrender his shareholding. So had they if they had had a founders agreement in place or a shareholders agreement in place, this wouldn't have arisen, because uh, the founders agreement, among a lot of other things, in terms of the respective roles and responsibilities of each and every founder, also highlights on what conditions the founders, if they wanted to exit the startup, on what conditions they will exit, vesting conditions, all that. So here you'll see not having a founders agreement and founders vesting. Okay. So from the founders agreement, we now come to the founders vesting. And in this very situation, because the founders had not had given a thought to founders reverse vesting, this exiting founder was just able to bargain with the help of a massive 49% shareholding of the startup. उसने सिर्फ 1.5 साल काम किया था, and then he just moved away with a handsome amount without having to do anything for it thereafter, right? So founders, okay, look, before I make this into a long, boring monologue, I also want all of you to I'll keep asking certain questions. Please feel free to answer them. Don't bother if they're right or wrong. It's okay. So anyone aware of what is founders vesting? What is the vesting of a share? Can anyone tell me? Is anyone aware? Anyone? What is the founders vesting?
Sir, giving it a try, sir.
Beg your pardon. Yes, please, please, please. Go ahead.
Sir, so when I was into an edtech startup, so I was allocated some ESOPs. So the vesting time, sir, when we can take away that ESOPs in terms of like whatever the founder or the agreement has been made upon. So the vest time period from when we have joined, when we have signed the agreement or when we have joined the company till the time we exit might be the vesting period.
Okay. I'll explain this a little further. Okay.
Yes.
So anyone else who wants to share with the I'm sorry, share with the rest of the group as to what they understand by founders vesting? Anybody? No? All right. So I'll explain this. Founders vesting means, see, when a company is incorporated, uh, let us assume there are two founders. So the shares, the subscribed shares of the company will be held by the two of these founders, right? In any proportion. It can be 70-30, 50-50, whatever it might be, or even 90-10 for that matter. Okay. Now, what vesting means is that, see, if those shares and the ability to transfer or sell those shares is available with the founders from day one or from the day of the incorporation. See, incorporation के लिए कितना पैसा भरना पड़ता है? I'll tell you, typically authorized capital, which is equal to the subscribed capital of a company, ये 1 लाख रुपया होता है. हाँ, और उसमें 10 रुपए के 10,000 shares होते हैं. Am I right? That is the typical standard sort of a configuration, right? हाँ ना, I mean, I don't know.
Sir, almost yes, sir.
Right? So, तो उसमें क्या होता है कि if let us say I am holding 50% and my co-founder is holding 50% of the shares. Now, after 6 months into the incorporation, I feel like, यार, this is not working for me. I want to move out. मैं क्या करूंगा? मैं मेरे जो 50% shares हैं, वो I will simply offer them for sale to someone. If the founders agreement does not have any restrictive covenants, and if there's no vesting, I will have the full authority to sell all my shares to anyone, okay, or transfer my shares to anyone, sell my shares to anyone. So उसमें ये होगा कि जो जब co-founders साथ में आके कोई startup शुरू करते हैं, obviously it is both their undertaking, right? So both of them, each of them is bringing something to the table, each of them is contributing something. So for example, एक typical example होता है कि एक बंदा जो है वो कोई technical expertise लेके आता है, दूसरा बंदा जो आता है वो sales या management या marketing का कोई expertise लेके आता है, right? I mean, it can be anything at all, right? Now, all of a sudden, at the early stage, a lot of the work is done by the co-founders themselves. All of a sudden आप सोचिए कि एक इतना की आदमी जो है कंपनी का, वो अगर छोड़ के चला जाता है, जिसके फॉर एग्जांपल जो एंटायरली टेक्निकल के इंचार्ज था, वो एकदम से छोड़ के चला जाता है, व्हाट विल हैपन टू द कंपनी? इट विल एब्सोल्युटली फॉल अपार्ट, राइट? नॉट जस्ट दैट, you guys tell me, if within 6 months of joining, if a co-founder just decides to leave, does he deserve to get any returns? उसने कितना पैसा भरा है? If he is holding 50%, उसने 50,000 रुपया भरा है. Now let us say after 6 months अगर कंपनी का वैल्यूएशन आता है 1 CR, हाँ, उसका 50,000 का वर्थ कितना है? 50 लाख रुपीस, राइट? तो 6 महीने में 50,000 का 50 lakh rupees and he just moves away, right? So it's not fair on the remaining founder जो अभी भी कंपनी में रह के काम कर रहा है, मेहनत कर रहा है, अपना समय दे रहा है, अपना पैसा डाल रहा है, अपना एफर्ट्स डाल रहा है, right? It's not fair to him. सो अ फाउंडर्स वेस्टिंग टिपिकली ये बोलता है कि जो भी शेयर, लेट अस से दिस टेक अ टिपिकल एग्जांपल, दो को फाउंडर्स हैं, हाँ, दोनों के पास 50-50% शेयर्स हैं. सो 5,000 दिस गाय, 5,000 दिस गाय. फाउंडर्स वेस्टिंग ये बोलता है कि फॉर द फर्स्ट ईयर, विच इज ये टिपिकल मैं टर्म्स आपको बता रहा हूँ जो नॉर्मली होते हैं इन मोस्ट ऑफ द फाउंडर्स वेस्टिंग. फर्स्ट ईयर इज समथिंग कॉल्ड अ क्लिफ पीरियड. क्लिफ पीरियड वो होता है जिसमें किसी भी फाउंडर को वो बोलता है कि 1 साल तक उसका एक भी शेयर ट्रांसफर करने का राइट नहीं मिलेगा. इन फैक्ट इफ ही लीव्स बिफोर कंप्लीशन ऑफ 1 year, he must mandatorily sell all his shares back to the company at a face value, which is what he has paid for it. ठीक है, तो वो होता है क्लिफ पीरियड. तो नॉर्मली जो टर्म्स होता है वो ऐसे होता है कि 50% या वॉट एवर द होल्डिंग, उसमें से 25% ऑफ 50%, विच इज लाइक 12.5%. तो 12.5% सिर्फ उसको एट द एंड ऑफ 1 year मिलता है. तो अगर कोई को फाउंडर 1 साल काम करेगा कंटिन्यूअसली विदाउट लीविंग द स्टार्टअप, तो उसको सिर्फ 12.5% ही शेयर्स मिलेंगे. या उसको मिलेंगे मतलब क्या, उसके ऊपर राइट मिलेगा टू सेल दो शेयर्स और ट्रांसफर दो शेयर्स फॉर कंसिडरेशन. ठीक है, एंड देन रिमेनिंग जो 75% है, विच इज 12.5, 12.5, 12.5, ये अगले 3 साल एट द एंड ऑफ द सेकेंड ईयर, थर्ड ईयर एंड फोर्थ ईयर मिलेंगे. विच मीन्स दैट अगर किसी को फाउंडर को अपना एंटायर 50% फ्री होल्डिंग शेयर्स चाहिए विद द एंटायर राइट टू ट्रांसफर देम, he will have to stick around in the startup for 4 years. ठीक है, तो तब उसका बनता है भाई, अगर किसी ने 4 साल डेडिकेटेडली किसी कंपनी को दिए हैं, तो उसको वो 50% के ऊपर एंटायर राइट्स होना, ये उसका बनता है. ठीक है, सो दैट इज अ फाउंडर्स वेस्टिंग. हमने और एक एग्जांपल देखा था जिसमें शुरुआत में वन ऑफ द को फाउंडर्स केम इन. In fact, the company approached that guy as a co-founder, and told him कि आप आ जाओ, because he had a great network, and he told them that he will help them sell their finished products. Okay, so they brought him on as a co-founder and gave him 26% of the equity right away. अब क्या हुआ कि उस आदमी ने उसके बाद एक दिन भी काम नहीं किया, 1 मिनट उस आदमी ने काम नहीं किया, उसने कोई सेल्स के लीड्स नहीं दिए. He did not put in a rupee of money after that. ठीक है, and he was simply holding on to 26% of the equity. ठीक है, अभी यहाँ पे जो 74% वाले जो हैं वो बेचारे मेहनत कर रहे हैं, and this guy is not doing anything. Now they wanted to fundraise. तो फंडरेज, दे डिड नॉट वांट टू डाइल्यूट देयर ओन इक्विटी. वो उसको बोल रहे थे कि सर आप कुछ काम तो नहीं कर रहे हो, आप आपका 26% डाइल्यूट करो, आप किसी और को बेच दो. यू आर लाइक नो, आई वोंट डू. ठीक है, सो दे वर फेस्ड विद दैट प्रॉब्लम, एंड अगेन मतलब we had to initiate certain legal proceedings against him, but again there, because vesting नहीं था, तो उसको लिटरली बिना कुछ काम किए, एंड फाउंडर्स एग्रीमेंट भी नहीं था जिसमें लिखा होता है नॉर्मली कि भाई जो जिसको भी इक्विटी मिल रही है, जो भी एज अ को फाउंडर स्टेटस पे आ रहा है, उसके ये रिस्पॉन्सिबिलिटीज रहेंगे, उसका ये केपीए रहेगा, केपीआईज रहेंगे. ठीक है, तो वो अगर उसने फुलफिल नहीं किए तो उसको इक्विटी नहीं मिलेगा. ठीक है, तो दैट इज व्हाई अ फाउंडर्स एग्रीमेंट and with founders vesting is extremely critical. ये नहीं होता है तो बहुत सारे प्रॉब्लम्स होते हैं स्टार्टअप में, स्पेशली जब कोई फाउंडर जो एक सब्सटेंशियल इक्विटी होल्ड करता है वो एग्जिट कर जाता है स्टार्टअप से. ठीक है, सो दैट्स द फर्स्ट. Second, not choosing the correct structure for your startup. What we mean by this is simply startup 3 तरीके का हो सकता है in terms of the corporate structure, right? LLP, registered partnership, and private limited company, right? तो इसमें से you have to really choose, be careful and choose the right लीगल स्ट्रक्चर फॉर योर स्टार्टअप्स। हर लीगल स्ट्रक्चर में कुछ प्रोज एंड कॉन्स होते हैं। जैसे रजिस्टर्ड पार्टनरशिप में आपको बहुत ज्यादा कंप्लायंसेस नहीं है, यू जस्ट हैव टू फॉलो द पार्टनरशिप एक्ट, लेकिन उसमें कंपनीज एक्ट, आरओसी, एमसीए ये कुछ नहीं होता है, ठीक है। उसमें रजिस्ट्रार ऑफ फर्म्स होता है, ठीक है, जहां पे आपको, बट उसमें भी द लेवल ऑफ कंप्लायंसेस इज वेरी माइनस्क्यूल कंपेयर टू अ प्राइवेट लिमिटेड कंपनी, ठीक है। हाँ, एलएलपी और प्राइवेट लिमिटेड कंपनी में बहुत ज्यादा फर्क नहीं है, ऑल्दो दैट इज अ मिसकंसेप्शन कि प्राइवेट लिमिटेड कंपनी में बहुत ज्यादा कंप्लायंसेस होते हैं, बहुत ज्यादा रूल्स फॉलो करने पड़ते हैं, और एलएलपी में नहीं होते। तो दैट्स अ मिसकंसेप्शन ऑफ अ लॉट ऑफ फाउंडर्स दैट वी हैव एनकाउंटर्ड। ओके, सो वो है one thing. The most popular structure is a private limited company, and why? Because it's the only structure which allows startups to dilute equity for fundraising, ठीक है। नॉर्मली जो इन्वेस्टमेंट होती है वो सब इक्विटी इन्वेस्टमेंट, इक्विटी बेस्ड इन्वेस्टमेंट होती है। कुछ कुछ होगी जो डिबेंचर या बॉन्ड्स मतलब डेट बेस्ड होगी, बट मेनली मोस्ट ऑफ इट इज ऑल इक्विटी इन्वेस्टमेंट। तो उसमें अगर आपके पास शेयर्स ही नहीं है तो आप इक्विटी क्या डाइल्यूट करेंगे, राइट? सो दैट्स व्हाई प्राइवेट लिमिटेड कंपनी इज द मोस्ट पॉपुलर फॉर्म ऑफ लीगल स्ट्रक्चर अडॉप्टेड बाय मोस्ट स्टार्टअप्स, ठीक है। हल्का उसमें कंप्लायंसेस ज्यादा होते हैं, बट the way I see it, startups should not look at it as a burden. Startups should look at it as an excellent opportunity to keep your house in order. Basically, Companies Act जितने compliances करने को बोलता है, अगर आप सही से वो follow करो, तो आपका जो स्टार्टअप है वो legally and compliance wise it will run very smoothly, ठीक है। अगर आप नहीं फॉलो करेंगे तो यू विल फेस प्रॉब्लम्स, ठीक है। तो इट इज लाइक अ स्ट्रिक्ट सॉर्ट ऑफ अथॉरिटी which makes sure that you are compliant, which makes sure that you follow all the laws and rules and regulations if you want to keep your startup running, ठीक है। तो that's as far as the legal structure is concerned. Typically registered partnership कोई जाता नहीं है, mostly you will find it is either an LLP or a private limited company, okay. Now, ignoring corporate secretarial compliances, how many of you are aware of what secretarial compliances are necessary for a private limited company? साल में कितने meetings होने चाहिए? Can someone tell me? एक private limited company के 1, 2, 3, 4, 5, 6? How many? You can put your answers in the chat box. So Dr. Aditi is saying 3, 4, minimum 1, right? So there are a lot of different perceptions among various founders, ठीक है। तो basically any private limited company must hold at least 4 BOD meetings, board of directors, that is 1 in every quarter, okay, and 1 AGM at the end of the year, okay, which is the annual general meeting. Another thing is that in between any 2 BOD meetings, board of director meetings, the gap should not be more than 120 days, ठीक है। तो ये बहुत इंपॉर्टेंट है, ठीक है। अब क्या होता है कि व्हेन यू कॉल दीज मीटिंग्स, सिर्फ मीटिंग्स लेना इंपॉर्टेंट नहीं है, उसका जो फाइलिंग्स करना है वो बहुत ज्यादा इंपॉर्टेंट है, ठीक है। सो व्हेन यू कॉल अ मीटिंग, ऑब्वियसली यू इशू अ नोटिस, राइट। आपका जो आर्टिकल्स ऑफ एसोसिएशन होता है उसमें उसका प्रोसीजर लिखा हुआ होता है, कंपनीज लॉ भी उसका प्रोसीजर देता है कि जब आपको बीओडी मीटिंग कॉल आउट करनी हो तो आपको कितने दिन का नोटिस देना जरूरी है। आपको उसके बाद अगर जनरल मीटिंग लेनी हो, विच इज आइदर एन एजीएम और एन ईजीएम, हाँ, तो आपको कितने दिन का नोटिस देना पड़ेगा शेयर होल्डर्स को, राइट। सो someone is asking, is there any standard format to make minutes of meetings of directors? Yes, there is a standard format. It is you can consult your company secretary. Typically secretarial compliances are done by them. If you don't have a competent CS, please make sure that you have one. because it is very important. I'll give you another example of one of our clients, startup, जिनका LLP था, 5 साल पहले incorporate किया गया. They had not done any filings with the ROC for 5 years. To give you an idea of how expensive this non-compliance can be, he had to pay a fine. जो initially जो fine compute हुआ था, that was around 6.5 lakh rupees for bringing all his compliances in order. 6.5 lakh rupees. Thankfully, due to his good luck, there was a recent change in the way that fine is calculated through a notification in April this year, जिसकी वजह से उनका वो फाइन कम होके 1.5 लाख रुपए पे आ गया. But still, any of you can tell me, as an early stage startup which is typically bootstrapped, self-funded, 1.5 लाख रुपया अगर आपको इसके लिए खर्चा करना पड़े, just as a fine, you are not achieving anything by it. Do you think that makes sense? It doesn't.
No.
Right? So please be very aware of secretarial compliances and make sure that you follow them. उसका हर चीज का एक टाइमलाइन दिया जाता है कि भाई एजीएम कब तक लेना है, आपका बीओडी कब तक लेना है, आपका after any meeting you have to make sure that the minutes of meetings are recorded in the format as specified by the Companies Act, and along with that uska jo, if there are any resolutions that are adopted by the company, it can be an ordinary resolution or a special resolution, you have to make sure that you do the ROC filing, जो फॉर्म MGT 14 वगैरह ये सब होता है, इसका फाइलिंग you must ensure that you do your ROC filings on time. ये आप ROC filings नहीं करते हैं टाइम पे, तो the example that I just gave you, आपको hefty penalties आपको फेस करने पड़ सकते हैं. ठीक है? So ignoring corporate secretarial compliances, common mistake, please do not do that. Okay? Next part, extremely important, not having contracts. देखिए आप जैसे बड़े होंगे, you will have vendors, you will have customers. कोई यहाँ पे B2B होगा, कोई यहाँ पे B2C startup होगा, कोई D2C होगा, right? Now, but everybody will have certain vendors who can either be product suppliers or service providers, right? तो मैंने कितनी बार स्टार्टअप्स में ये देखा है कि स्टार्टअप्स डू नॉट बॉदर entering into written contracts with any of these vendors and suppliers. Okay, वो मुंह बोली पे काम चलता है. तो पुराने जमाने में ये ठीक था, ठीक है, लेकिन अगर आपको आपके स्टार्टअप को एक स्केल देना है जहां पे you wanted to make to run really like a corporate entity, like a large corporation, आगे चल के अगर आपको वो होना है, तो the most important thing is documentation. And in these written contracts with your vendors, your customers contain extremely important protective provisions, जो आपको आपकी रिस्क जो है, आपका अनसर्टेनिटी जो है वो काफी कम कर सकती है. I'll give you an example of such terms which you must be really aware of when if you do not have written contracts with your vendors and customers, please make sure that you do that right away. ठीक है? इसमें अभी क्या होता है कि स्टार्टअप फाउंडर्स टिपिकली जस्ट पे अटेंशन एट ओनली 2 थिंग्स, कि क्या प्रोडक्ट या सर्विस या तो लेना है या तो प्रोवाइड करना है, एंड देन अलोंग विद दैट उसके कमर्शियल्स, सिंपल, पैसा कितना लेना है या देना है, राइट? बट nobody bothers looking at clauses like force majeure, nobody bothers looking at clauses like indemnity or limitation of liability, all that, right? या arbitration clause है या नहीं, कौन देखता है? How many of you guys know what arbitration is? How? अच्छा, बस just by writing yes in the chat box, tell me, out of the many people who are attending, how many of you actually have agreements with your vendors and customers? Just write yes. So how many people are attending? How many people do we have? right? So happy to see a lot of yeses and some no's. Okay, but I see a lot of yeses. That's great. That's great, guys. So ये बहुत ज़्यादा important है, ठीक है? Because it is not just about what product or service you are availing or providing and the money. Other terms are equally important. For example, there is a term called indemnity. Okay. Yeah. So coming back to arbitration, arbitration means hiring mediator for disputes. Yes, I mean in one way, if you look at it, yeah, fair enough. But I'll tell you what arbitration means. Arbitration ये बोलता है कि arbitration simply means it's an out of court process by which you can resolve your disputes. Okay, between the contracting parties. तो एक कोई भी एग्रीमेंट है या कॉन्ट्रैक्ट है, वो पार्टीज के बीच में अगर कोई भी डिस्प्यूट होता है तो उसको रिजॉल्व करने के लिए देयर इज एन आउट ऑफ कोर्ट प्रोसेस विच इज कॉल्ड आर्बिट्रेशन, जो पार्टीज फॉलो कर सकती हैं टू गेट देयर डिस्प्यूट्स रिजॉल्व. अब ये क्या होता है कि इसमें एन आर्बिट्रेटर इज अपॉइंटेड, जहां पे आपने मीडिएटर ये नाम लिखा है, तो जस्ट रिप्लेस दैट मीडिएटर विद आर्बिट्रेटर, राइट? सो देयर इज एन आर्बिट्रेटर, ही इज अ न्यूट्रल थर्ड पार्टी जिसको दोनों साइड्स अपना अपना पक्ष रखती हैं उसके सामने, एंड द आर्बिट्रेटर देन डिसाइड्स on a amicable solution to that dispute without the parties having to go to the court. How is this useful? Number one, everybody knows how time consuming court procedures can be, right? तो एक dispute आप अगर कोर्ट में चले जाते हैं to resolve, let us say there is a breach of contract, हाँ, आप अगर कोर्ट में चले जाते हैं, if you are lucky, that dispute might get resolved in 6 months to a year. If you are lucky, if you are really lucky. If not, I mean, God help you. I mean, कितना भी टाइम लग सकता है. Now, is it really worth a startup founder's time, who's already doing everything himself, to run to the court har tarikh pe and for one dispute? It's not, right? Because you already have your hands full. Startup founders literally all-rounders होते हैं जो हर काम करते हैं, right? I've seen that. So it's not worth your time going to the court and paying lawyers like me to fight on your behalf in court. It's very expensive and it is also very time consuming. So being a lawyer, being an advocate myself, I'm telling you this. If you do not have arbitration clauses in your contracts, please read them again and insert those arbitration clauses. It gives you and the other party an option to go for an out of court settlement of that dispute. And the best part is that it is governed by an act or a law called the Arbitration and Conciliation Act. तो अगर arbitration कोई आपका समाधान देता है, कोई award देता है in judgment of the dispute, then you don't have to go to the court for the same dispute again. Okay. So it's a very, very effective mechanism to settle your disputes outside court in a very formal mechanism, in a very regulated mechanism. The other great part about an arbitration is that इसका procedure दोनों parties ही decide करती हैं. ये court या कोई और decide नहीं करता है. So that's great, right? You can also mutually appoint the arbitrator. So arbitration agreement में अलग-अलग तरीके से arbitrators appoint किए जाते हैं. It can either be one sole arbitrator mutually appointed by both parties, or it can have the provision कि भाई दोनों parties court के पास जाएंगी and court appoint करेगा arbitrator, या ऐसे भी होता है कि दोनों parties एक-एक arbitrator appoint करेंगी and वो दोनों arbitrators एक third arbitrator को appoint करेंगे, and then the panel of 3 arbitrators will then sit to arbitrate your dispute. So it is entirely in the hands of the parties in terms of the procedure for this process. That's why arbitration is extremely important. And this is just part of your written contracts. अगर आपके पास written contract नहीं है, तो you are in deep trouble. ठीक है? I have seen so many disputes happening जो नहीं होते अगर उनके पास एक well-defined written contract होता parties के बीच में. Because anything can go wrong, right? I mean, फोन पे आपने बात कर लिया, भाई मुझे ये एक चीज चाहिए, मुझे आई वांट a supply of, let us say, some raw materials by by the 10th of this month. उसने सुन लिया by the 10th of next month. हाँ, and then he sends you by the 10th of next month, sends you a bill. आप बोलते हैं अरे भाई अभी ये मेरे काम का नहीं है, मैंने आपको बोला था 10th of this month. वो बोलेगा no, I heard you you had said 10th of that month, next month. So you know, ऐसे हजार टाइप के प्रॉब्लम्स हो सकते हैं if you do not put your contracts, your agreements in writing, in black and white. So please do that. Please have crucial terms like your indemnity, your force majeure, arbitration, limitation of liability, and so on and so forth into these contracts. Okay, so that's not having written contracts, which is a big mistake. Not having employee contracts, बहुत common है. How many of you do not have employee contracts, employee agreements? And if and I've seen this ये बहुत common चीज है. मेरे 4 या 5 स्टार्टअप्स के साथ मैंने ये देखा है. when they came to us, मैंने पूछा सर एम्प्लॉय कॉन्ट्रैक्ट है क्या, तो बोले हाँ. मैंने बोला दिखाइए. They showed me an NDA, a non-disclosure agreement. Please understand, a non-disclosure agreement is not an employee agreement. Employee agreement has far more comprehensive clauses which are for your protection, for the protection of the startup, right? Which an NDA does not have. NDA सिर्फ इतना ही बोलता है कि भाई ये जो डेटा और इंफॉर्मेशन हमारे बीच में एक्सचेंज होगी वो कोई पार्टी किसी को डिस्क्लोज नहीं करेगी एंड इसको कॉन्फिडेंशियल रखेगी. ठीक है, दैट्स इट. It does not cover extremely important clauses like your protection of intellectual property, work for hire, or your non-compete, non-solicit. Moonlighting का सब लोग problem देख रहे हैं, right? Everybody knows about moonlighting, इतना famous term हो गया है. So imagine your employee working for you and then simultaneously without your knowledge working for your competitor. आपको पता चलता है बट आपके एम्प्लॉयमेंट एग्रीमेंट में नॉन कम्पीट का क्लॉज ही नहीं है. आप क्या बोलेंगे उसको? He has done nothing wrong. So that that is why clauses like non-compete, non-solicit are extremely important. मैंने कितनी बार ये देखा है कि एम्प्लॉइज प्रोटेक्शन ऑफ आईपी के लिए एम्प्लॉयमेंट एग्रीमेंट कितना ज्यादा इंपॉर्टेंट है. Does anyone know what is a works for hire? Can anyone tell me? वर्क फॉर हायर क्या होता है? द कंसेप्ट ऑफ अ वर्क फॉर हायर? नो यार, इज दिस सो बोरिंग दैट एवरीवन इज स्लीपिंग?
So we don't know. I really don't know.
Fair enough. So all right, so yeah, so now I can see some people replying in the chats. No problem. See, so work for hire basically means what it means is that when your employee, whatever intellectual property he creates in terms of the content, so it can be code, it can be software code, it can be designs of products, it can be any other literary works, right? For example, some creative content, it can be any process or innovative product which he has come up with or invented, something like that. तो works for hire ये बोलता है कि the intellectual property rights in any such content or work created by your employee is owned by the company and not him. So what we write is that, or what we include in that clause is that it shall be deemed that any the company shall own the intellectual property rights in any content or work or material created by the employee in the course of his employment, and it shall be deemed to have been assigned to the company immediately on creation of that intellectual property, right? तो और ये मैंने देखा है, ये नहीं है. एक स्टार्टअप था जहां पे उनका अगेन दिस सेम स्टोरी ऑफ एन एनडीए. मैंने उनको बोला था कि सर आपका एम्प्लॉयमेंट एग्रीमेंट है क्या? उनका आई विल टेल यू व्हाट हैपेंड. वन ऑफ देयर एम्प्लॉइज, उनको इन्होंने भी कुछ एश्योरेंसेस देके उन्होंने ऑनबोर्ड किया था. ठीक है, कि हम आपको ईसॉप देंगे, ये देंगे, वो देंगे, प्रमोशन देंगे आफ्टर so many years, XYZ, whatever, and he came on board. Again, no employee agreement, which puts these terms down in black and white. सब मुंह बोली चल रहा है, बढ़िया चल रहा है. हाँ, now this guy was here in the company for around 2 years. उसने काफी सारा काम किया. They were into software development, some unique software. He was the main coder. Okay. They did not have an employee contract, and उनका जितना चाहिए वैसा उनको मार्केट में ट्रैक्शन नहीं मिल रहा था, जिसकी वजह से they could not fulfill their promises to him. These were all oral promises, again, not written. ठीक है, तो because employment agreement तो था ही नहीं, तो हुआ ये कि he went to them and asked them कि सर आपने मेरे को बोला था आप मेरे को ESOP देंगे इतना X%, आपने मेरे को बोला था आप मेरे को प्रमोशन देंगे एंड you'll pay me such and such a salary, तो प्लीज दीजिए मेरे को. तो they were like नहीं अभी तो सिचुएशन खराब है, ये है वो है, all that happened. You know what he did? He just copied the entire code onto a pen drive and stopped coming from the next day. And they came on to their knees. घुटने पे आ गए वो लोग उसको भीख मांगने के लिए कि भाई आजा, तेरे को कुछ तो करते हैं. And then they had to settle. So just imagine, ये दोनों तरफ से गलती है. ठीक है, एक एम्प्लॉयमेंट एग्रीमेंट नहीं है जिसमें ये वाटर टाइट क्लॉज हो कि भाई you cannot do that. Number one, confidentiality, non-disclosure. You cannot use any of the work that you have created for the company anywhere else. You cannot disclose it. You'll have to keep it confidential. And the company shall own all rights in and to the work created, including this code जो इस बंदे ने लिखा था. ठीक है, they did not have that in place. Also they were wrong in the sense that they did not honor their commitments to him. ठीक है, so he just walked away with the code, and they faced such a hard time getting him back. But imagine what had happened if he had not come back. खत्म था उनका प्रोडक्ट. ठीक है, and they wouldn't have been able to do anything against him in terms of a legal action because there was no agreement in place. कोर्ट में जाके क्या बोलते हैं कि सर इसने क्या किया है, हमारा कोड लेके भाग गया है. वो बोलेगा आपका कहाँ कोड है, मैंने ही डेवलप किया है. राइट. So all these kinds of problems arise if you do not have pakka employee contracts in place. Please do have them. Clauses like your non-compete, non-solicit. Non-compete ये बोलता है कि during the time of your employment with the startup, आप किसी competing business कोई भी नहीं करेंगे, ना खुद करेंगे, ना किसी रिश्तेदार के साथ करेंगे, ना दोस्त के साथ करेंगे, ना कहीं पे काम करेंगे as an employee or as a vendor or in any capacity. ठीक है, वो इतना वाटर टाइट क्लॉज होता है कि दे कैन नॉट डू एनी सच अ थिंग. ठीक है, so that is very important. If the person is doing such work but he is expert, not the employee of the company, how is the contract? Yes, so then you will have a consultant contract. Is he working in the capacity of a consultant, Sonali? Right. So if he's working in the even if he's working in the capacity of a consultant, you must have a consultant contract. See, in the end, you are paying for his work, right? You are paying for his work. Then why shouldn't you own it? उसी बेसिस पे आपने काम करना चाहिए कि भाई आप जो हमारे लिए ये काम कर रहे हो, ये आप किसी कॉम्पिटिटर के लिए नहीं करेंगे, या आप खुद हमारे कंपटीशन में नहीं उतरेंगे सेम चीज लेके. ठीक है, ये अगर आपको मान्य हो तो ही हम काम करेंगे साथ में. ठीक है, अंडरस्टैंड. सो even if he's not an employee, if he's an external consultant, you can still get into a consultant contract with him which places all these restrictions. देखिए, नॉन कम्पीट, नॉन सॉलिसिट, ये जो, अच्छा, नॉन सॉलिसिट, डज एनीवन नो व्हाट नॉन सॉलिसिट मींस? नॉन सॉलिसिट मींस कि अगर मैं छोड़ के जाता हूं कंपनी, तो मैं इसी कंपनी के दूसरे एम्प्लॉइज, वेंडर्स, कस्टमर्स को मैं पोच नहीं करूंगा. राइट. अदरवाइज क्या होता है, एंड अगेन अ वेरी कॉमन सिनेरियो, एक एम्प्लॉय छोड़ के जाता है, और जो खुद बेचारा काम कर रहा होता है सब, ठीक है, ही डज नॉट लाइक समथिंग, वो अपने साथ पूरी टीम को लेके जाता है, वो खुद एक अकेला नहीं जाता, राइट? तो व्हाट विल यू डू इन सच अ सिचुएशन? तो नॉन सॉलिसिट क्लॉज वही बोलता है कि इवन इफ यू एग्जिट, यू विल नॉट solicit any employee or vendor or customer of the company to terminate their engagement with the company. So, or cause an employee to terminate his employment with the company in order to join somewhere else or do anything else, right? So that's a non-solicit. There's also something called a non-disparagement clause. Non-disparagement clause ये बोलता है कि आप बैड माउथ नहीं करेंगे कंपनी को बाहर जाके, ठीक है, अगर आप उल्टा सीधा नहीं बोलेंगे. सो इट्स वेरी कॉमन नाउअडेज, सोशल मीडिया का सबको एक्सेस है, एवरीबॉडी ओवर हियर हैज सोशल मीडिया अकाउंट्स. मेरे को आई हैव सम डिस्प्यूट विद द कंपनी, मैं जाके मेरे ट्विटर पे लिख देता हूँ, आई टैग द कंपनी, आई टैग द सीईओ, द को फाउंडर्स, एवरीवन, दुनिया भर को मैं टैग कर देता हूँ, एंड मैं कुछ उसमें बुरा भला लिख देता हूँ, ठीक है, कंपनी के बारे में. तो इमेजिन इट्स अ बिग ब्लो टू द रेपुटेशन ऑफ अ स्टार्टअप जो जिसने अभी अभी अपना रेपुटेशन बनाना शुरू किया है, ठीक है. तो नॉन डिस्पैरेजमेंट क्लॉज ये बोलता है कि यू वोंट डू एनीथिंग ऑफ दैट सॉर्ट, ठीक है. सो that's a non disparagement. So all these important clauses must be there in your employee contracts. Very very important, ठीक है. If you don't have them, you may face all these problems, and ये सारे problems हमने खुद देखे हैं अलग अलग startups के होते हुए, right? Not protecting intellectual property. I'll give you a beautiful example of not protecting intellectual property. एक startup हमारे पास अभी आया है, ठीक है, and he's facing this problem. So he is into fast food. फास्ट फूड का उन्होंने कुछ एक इनोवेटिव फास्ट फूड प्रोडक्ट बनाया है, ठीक है, जिसका अभी उन्होंने थ्रू कियोस्क अलग अलग जगह पे सेटअप करना शुरू कर दिया. नाउ दे आर गोइंग टू गिव आउट फ्रेंचाइजीज ऑफ दोज ऑफ दैट प्रोडक्ट. तो उनका जो नाम है, ठीक है, वो इतना कॉमन नाम है, दे हैव नॉट रजिस्टर्ड द ट्रेडमार्क फॉर दैट नेम. इनफैक्ट नाम ही इतना कॉमन है कि दो एक सिंपल वर्ड्स को ज्वाइन, ए एंड बी, समथिंग लाइक, सो ए इज अ वेरी कॉमन वर्ड, बी इज अ वेरी कॉमन वर्ड, ठीक है, विच आर टिपिकली टेकन टुगेदर, ठीक है. सो समथिंग लाइक अ शूज एंड लेस, ठीक है, इस तरीके का, नॉट एग्जैक्टली दिस, बट फॉर द पर्पज ऑफ कॉन्फिडेंशियलिटी ऑब्वियसली आई कांट टेल यू देयर नेम, बट इस तरीके का कुछ कॉमन सा नाम उन्होंने रखा हुआ है, ठीक है, and they are running this thing. Now, you know what problem they are facing? They are unable to get a trademark for this name, and उनको अभी फ्रेंचाइजी देनी है, because trademarks are not allowed for such common or generic words. For example, आप something like a management consultants private limited, ऐसा आप अगर करने जाए तो आपको ट्रेडमार्क नहीं मिलेगा, ठीक है. और यू स्टार्टअप फास्ट फूड चेन जिसका नाम आपका है वड़ा और पाव, आपको उसका ट्रेडमार्क नहीं मिलेगा, बिकॉज दे आर जस्ट टू कॉमन जेनेरिक वर्ड्स, देयर इज नथिंग यूनिक अबाउट देम. सो ये ट्रेडमार्क का अलग अलग क्राइटेरिया होता है जिसके आपका ट्रेडमार्क मिलता है या नहीं मिलता है, ठीक है. सो नाउ दे फेस दिस प्रॉब्लम. नाउ द प्रॉब्लम इज दैट दे हैव ऑलरेडी सेट अप अराउंड 15 odd kiosks in other, there's another state जहां से वो आते हैं, वहां पे इट इज वेरी पॉपुलर, वहां पे वो ब्रांड ऑलरेडी बन चुका है, ठीक है. तो नाउ देयर प्रॉब्लम इज दिस कि अभी अगर वो रीब्रांड करने जाए तो उनके इस एग्जिस्टिंग ब्रांड ने जो ब्रांड इक्विटी बिल्ड की है, तो ये खत्म हो जाएगी, because then I mean they'll have to rename all their existing kiosks and outlets, and अगर नहीं करेंगे और सेम ही तरीके से कंटिन्यू रखेंगे तो लिटरली उनकी बगल में कोई और आदमी आके उसी नाम का एक स्टॉल लगा सकता है, एंड दे वोंट बी एबल टू डू एनीथिंग अबाउट इट बिकॉज द ट्रेडमार्क इज नॉट रजिस्टर्ड. आप समझ रहे हैं ये कितना इंपॉर्टेंट है, ठीक है. No, so trademarks are only restricted to a country. A trademark copyrights are global, patents are global, trademarks are not. Trademarks are restricted to a country. Okay, so यहाँ पे you can have some name. US में same name का कोई और कंपनी हो सकता है, चलता है, ठीक है. Sir, is there a fast track judiciary system to solve these matters? Unfortunately, there is no fast track judiciary system to solve specific matters like these. There are commercial courts, okay. So, but yes, they do have their own procedure. They do take their own time. एकदम civil court जितना time नहीं लगता है. There are commercial courts जहाँ पे ये commercial matters जाते हैं. But yes, I mean, being a court, they are literally riddled with thousands of these cases. So it's not that easy even for a commercial court to quickly dispose of different matters unless they are very, cut and dry. Simple है कि, black and white में है. तब तक वो नहीं होता है. Obviously, दोनों parties अपना अपना पक्ष रखती हैं, and there's a lot of, give and take over there in terms of evidence and what, arguments and this and that. Time तो लग ही जाता है, ठीक है. So that's not protecting the intellectual property. Not protecting intellectual property, employees के इसमें भी आपका जो मैंने works for hire वाला बोला था, उसमें भी ये important है कि employee जो भी आपके लिए काम करता है, उसका entire intellectual property rights ये कंपनी का होगा, ना कि employee का. Anup wants
Yes,
to
sir.
ask
Yes.
something. Yes, Anup.
Sir, as you said that intellectual property, like the concept of work for hire. So in this concept, the intellectual property is owned by the company. Sir,
Yes.
and some of the company also allows for side business to the employee under written approval by the HR. Sir, so if in this case, suppose I'm working with the IT industry, and inside of my inside business, I'm working for a working as a journalist for some company.
So you're saying non-related work you're doing. See,
Yes.
be that as it may, Anu, it is not just about non-compete or work for hire. Okay. It is also about you being able to dedicate your entire energy and expertise to your company. Okay. So, if the agreement between you and the company is clear कि भाई आप half day यहाँ पे काम करेंगे, half day आपको जो मर्जी आप बाकी कर लीजिए, ये अगर ये agreement है तो बात अलग है. But otherwise, you have to be in your full-time employment. अगर आप full-time employment में हैं, तो आप कुछ और नहीं कर सकते unless the company has explicitly allowed you. ठीक है?
Okay.
हाँ.
Sir, can I ask one question?
Yes, please.
Sir, full rebate on service fees for registration of trademarks, you said. So, whether it is there any procedure for that or what?
So I'm glad you asked that question. AIC Pinnacle is an IP facilitator. Udayji, am I right?
Yes, you're right. We are
Right. So you are in the best place possible for that. See, Prashantji, are you a registered startup? That is, do you have your DPIIT recognition done?
Yes, we have.
Right, perfect. So once you are a DPIIT recognized startup, if you approach any certified IP facilitator, so there's the IP facilitation scheme under the Startup India scheme of the government. So there are these registered IP facilitators, जिसके थ्रू अगर आप ये ट्रेडमार्क रजिस्ट्रेशन करवाते हैं, तो you'll get this rebate and this entire refund. और ये आपका जो सर्विस चार्ज वाला जो ये है.
How do I find that IP facilitator?
That's what I'm saying. That's what I'm saying. AIC Pinnacle is the IP facilitator, sir.
Okay. Thank you.
And if at all you're not based in Pune, if you go to startupindia.gov.in, उसमें resources के अंदर पूरा all India list of registered IP facilitators is available for downloading.
Okay. Thank you.
Yeah. Okay. Yeah. So not protecting your. Who's this?
Sir, my name is Ashish Dixit.
Uh-huh.
I want to ask a question,
Ashish
sir.
bhai, can we do one thing?
Ji,
I just request users to note down their questions. I think we have
ji.
earmarked some time for questions. I think we're already, the time is
Okay, okay,
over.
okay. No problem.
But we'll quickly run through the rest of the
Sure, sure, sure.
presentation, and then we will take all questions together. Is that okay?
Okay. Yeah, sir. Sure.
All right. Thanks a lot. Thanks a lot. Yeah. So yeah, the next mistake is trying to DIY everything. Everybody knows what DIY is. Do it yourself, right? Now, obviously, you'll say that we cannot afford so many different employees and vendors and service providers and consultants and this and that. I agree. Okay, but please understand that as a startup founder, your core area of expertise is in your product or your service, in developing that. Okay, if you do not spend all your time and focus on that, understand that you will not achieve the best result possible. तो क्या हो जाएगा अगर आप फोकस से काम करते हैं तो आपका जो प्रोडक्ट है, सर्विस है, जो अर्ली स्टेजेस में अंडर डेवलपमेंट होता है, that you'll be able to, let us say, and if you are doing everything yourself, आपको उसमें 3 साल लग जाएंगे probably, या 2 साल लग जाएंगे. वही अगर आप प्योर फोकस करें एंड सी अंडरस्टैंड कि जब तक आपका डेवलपमेंट पूरा नहीं होता है तब तक कमर्शियलाइजेशन शुरू नहीं होता है, राइट? आपका ट्रैक्शन नहीं शुरू होता है, योर रेवेन्यू डजंट स्टार्ट फ्लोइंग इन. कैश फ्लो सबसे इंपॉर्टेंट चीज है, ये everyone should keep that in mind. Every startup should keep that in mind. Cash flow is everything. ठीक है? Valuation this that चलता रहेगा, but in the end, if you are not cash flow positive, sooner or later you are going to run out of money. ठीक है? And you are going to go down under. So for that cash flow, it is important that you quickly develop your product or service through focus. है ना? तो अगर आप वही समय जो आप हर काम खुद करने में लगा रहे हैं, तो if you do that yourself, you'll take 2 years. If you do not do that yourself, you have people appointed for that. The same thing you'll do in 1 year, you'll complete in 1 year and quickly start to commercialize. आपकी गाड़ी आगे बढ़ेगी. ठीक है? How many? I think a lot of you are Marathi over here. Yes. Can those of you who are Marathi please answer yes in the chat box? It's a lot of them. So there's a saying in Marathi, एक कहावत है. For those who don't understand, I'll just say it in Marathi and I'll translate it into Hindi. मराठी में एक कहावत है, बैल मेला ओझानं आणि शिंगरू मेला हेलपाटानं. So what it means is that बैल जो है वो तो फिर भी काम कर करके मर गया, कि अपने बोझ ढो रहा था, गाड़ी ढो रहा था. उसका जो बछड़ा है वो तो बस उसके पीछे भागने में मर गया. तो जो बछड़ा है, he did not really achieve anything. वो बस भागा दौड़ी करते रह गया और उसी में उसकी एनर्जी खत्म हो गई. ठीक है? तो अपने को वो मरने वाला बैल भी नहीं होना है. ठीक है? बट वो आप बैल बनेंगे तो आप फोकस करेंगे on your product or service development and leave the rest to the experts. Also ये भी है कि if you appoint experts for your specific requirements, they know the ins and outs, they are updated with the latest developments in that particular field. जो कंपनी सेक्रेटरी है वो जानता है कि कंपनीज एक्ट में इट इज वेरी डायनामिक, उसमें क्या चेंजेस आए हैं. जो टैक्स कंसल्टेंट है वो या सीए है वो जानता है कि जो टैक्स रूल्स है उसमें क्या चेंजेस आए हैं, क्या फाइलिंग्स में चेंज करना है, फॉर्मेट चेंज हुआ, ये है वो है. जो लॉयर है वो जानता है कि भाई कॉन्ट्रैक्ट कैसे ड्राफ्ट करना है. हाँ, सो ये सारे जितने आपके सर्विस प्रोवाइडर्स हैं अलग अलग, दे आर एक्सपर्ट्स इन देयर फील्ड बिकॉज दे आर ऑल्सो डूइंग द सेम थिंग. वो फोकस कर रहे हैं अपने फील्ड पे. आई एज अ लॉयर डू नॉट डू मार्केटिंग. मैं वो नहीं करता, मैं सिर्फ लॉ का काम ही करता हूँ. आई डू नॉट डू अकाउंटिंग फॉर माई फर्म. वो उसके लिए मैंने अकाउंटेंट रखा हुआ है. आई डू नॉट डू एनीथिंग. एनीवे मार्केटिंग हमको तो अलाउड ही नहीं है, so that's out of the question. But we do have IT systems. We do not do it ourselves. We have a IT guy who comes in, वो सब चेक करता है, वो सब ठीक ठाक है, चला जाता है. We just pay him, right? So we can focus on our core job, which is legal consultancy to startups like you. राइट. सो ट्राइंग टू DIY itself, एंड उसमें बहुत सारे लीगल मिस्टेक्स भी होते हैं, ये हमने देखा हुआ है. फॉर एग्जाम्पल, जो मैंने आपको बोला कि एम्प्लॉयमेंट कॉन्ट्रैक्ट के नाम पे NDAs लगा रखे थे. मैंने बोला सर ये कहाँ से मिला? सर वो गूगल से टेम्पलेट मिला हमको, तो हमने उसमें लगा दिया. उस टेम्पलेट में मतलब एक तो महाशय ऐसे थे कि जिसमें टेम्पलेट किसी और कंपनी का था, उस कंपनी का एक दो जगह पे उस कंपनी भलते ही कंपनी का नाम था उसमें टेम्पलेट में. I mean, just imagine what happens, right? So, this is what happens when you try to DIY everything. So please do not focus on your core job, focus on your product, service, whatever it is, and let the experts do their job. That way, you are also safe and you can sleep peacefully at night, right? And ignoring essential registrations, licenses, and other such statutory requirements. Registrations में आपका obviously DPIIT registration है, your MSME registration ये है, and every industry has its own licenses for specific things. So आपका अगर food processing में है, आपको food license लगेगा. आप कोई सॉफ्टवेयर सर्विसेज प्रोवाइड कर रहे हैं, उसमें कुछ स्पेसिफिक लाइसेंसेस होंगे और परमिट्स होंगे. you'll need to have all those license copies of all the softwares that are required. Statutory requirements कितने सारे होते हैं. फॉर एग्जाम्पल आपका ऑफिस है तो उसमें शॉप एक्ट लाइसेंस होना चाहिए, ऑल दैट, राइट. सो ये अगर आप इग्नोर करेंगे, इसका बहुत serious consequences हैं. You can face a lot of legal penal action. You do not want that. You want to focus on growing your startup. You do not want to be hassled by the government, harassing you for something which you would have easily taken care of earlier, which was very easily avoidable and preventable, right? So take care of this. Lastly, ignoring tax compliances, very, very important. Make sure that you have a proper tax consultant, a CA, an auditor, all those things, who can guide you through tax compliances. Jahan pe required hai, he can guide you in terms of all the exemptions that you can get, all the discounts that you can get, all the rebates that you can get. He'll help you in proper treatment of your accounting so that you're able to save as much tax as possible. And then make sure that you are filing your tax returns absolutely on time. GST jahan pe applicable hai, GST filings are very critical. Please make sure that you're doing that. So tax compliances, again, tax ka query aa gaya, bura faste hain. See, it's as simple as this. As long as you are compliant, nobody looks at you. Nobody looks at you. ठीक है. The moment they find one fault, फिर वो जो स्क्रूटिनी में जाते हैं, फिर उसमें एक गलती नहीं निकलती, उसमें 10 निकलती है. एंड फिर जो आपको लग रहा था कि यार ठीक है इसमें 10,000 फाइन भरेगा होगा, वो 1 लाख तक चला जाता है, 1.5 लाख तक चला जाता है. सो प्लीज मेक श्योर दैट योर टैक्स कंप्लायंसेस आर एब्सोल्युटली ऑन टारगेट. डू नॉट इग्नोर दोज. ये होता है, एंड देयर आर वेरी वेरी हेफ्टी पेनल्टीज. You do not want to get into all that, right? Yeah, this is very important. Again, fundraising के time पे ये होता है. Diluting too much equity at the early stage. One of the founders who came to us, prior to his fundraising, उसको investor ने बोला था, I'll put in X amount of money and I'll acquire 45% stake. That was his first round. That was his pre-seed. Imagine pre-seed में he is giving away 45% of his equity. ठीक है. Tell me what will remain with him for the rest of the rounds? कुछ नहीं. दूसरा, imagine the kind of control of the company that he is giving away. He had given away equity shares. So without that investor's approval, he cannot pass any special resolution. So special resolutions जो होते हैं वो critical होते हैं for running any organization. Those are the critical decisions. इसमें 75% से ज्यादा का अप्रूवल लगता है शेयरहोल्डर्स का. They are special resolutions. So not only are you giving away too much control of your startup, you're also giving away your opportunity at future fundraisings, in future rounds. So please do not make that mistake. Make sure that you have enough equity at at every funding stage. You do not dilute too much. Only spend as much as is absolutely minimally necessary. That way you control your expenses, and that way you also control your funds requirement. See, the more you require funds on the more you burn cash, the more funding you are going to require. And the more funding you're going to require, the more equity you are going to dilute. इसमें कोई दो राय नहीं है. So once an investor comes in, unless he's getting a really attractive appreciation on his investment, he's not going to dilute his stake. मैंने एक बार 45% dilute कर दिया at a X valuation. मैं जब तक 5x नहीं मिलता है, मैं नहीं dilute करने वाला मेरा. तो तब तक आप क्या करेंगे? I am sitting on a nice 45% or 40% or some such very substantial amount of equity of your startup. How are you going to raise further rounds? तो फिर आप ही minority shareholder उसमें होके रह जाएंगे at a very early stage. You don't want that, right? And last thing that I haven't included over here is that इस सब का जो सार है वो मैं बता रहा हूँ. Do not ignore legal aspects. ठीक है? Please make sure that you have all this in place. I have an announcement to make. So we are very soon coming up with a legal guidebook, a sort of a kit which will help all of you understand the basic legal concepts which you will encounter from your ideation phase to your maturity stage. I cannot tell you when we can release that, but we are very close to finalizing it, and we are going to make it available absolutely free of charge to everyone, along with AIC Pinnacle, okay, in association with AIC Pinnacle. So once that comes out, I'll make sure, or Uday bhai will make sure to share it with all of you. But that's a small effort from our end to help the startup ecosystem and fraternity in understanding the legal implications, right? So yeah, that's about it. We are startup legal. In case of any other doubts, you can, we'll try to take as many doubts as we can right now. I'm not sure, Uday bhai, how much time we have. We've already overshot by 10 minutes. But if there are any other doubts which we are not able to satisfy in this session, you can write to us at this mail ID, mail@thestartuplegal.com, or my personal mail ID, which Uday bhai will provide to you later in the session. I'll be more than happy to help you out. All right?
Okay.
So that's it. Any questions?
Sir, I have one.
Yes, please.
Sir, if suppose the founder or the director of the company has allocated some of the ESOPs, means on an agreement, and like he have not combined that 2 years bond with it, but he have written it separately somewhere 2 years.
Separately how?
Like on the same agreement, he has written the employees would be working for the company for 2 years.
Of course, see,
like
ESOPs में जिसको vesting period बोलते हैं, तो ESOP का vesting period is different from a founder's vesting. ESOP में vesting period वो होता है जो, जैसे अनु भाई अभी बोल रहे थे, कि that is the minimum amount of time that you must stay with the company before you can actually exercise your ESOP. Okay, so you must stay, the employee must stay with the company. अगर वो उसके पहले छोड़ जाता है, तो he cannot exercise the ESOPs.
Okay. Sir, suppose the employee has exercised his 2 years of time there, but meanwhile all the employees do not have that. They have to take the share certificate or whatever it is, and it was just on the agreement and not on the share certificate. So, sir, this case becomes.
So you're saying the employee did not exercise his ESOP, is it?
The director did not share the share certificate with the employee.
So नहीं, so see, share certificate तब आएगा जब employee ने ESOP exercise किया होगा, right? So see, ESOP is an option. Understand that ESOP does
Right,
not
sir.
ESOP is not sweat equity. Please understand. ESOP ऐसा नहीं है कि ठीक है आपने 2 साल कंपनी के साथ बिता लिए तो आपको सीधा शेयर मिल जाएंगे. नो, दैट्स नॉट हाउ इट वर्क्स. ESOP ऐसा होता है कि आपको एक एक्सरसाइज प्राइस होता है, ठीक है, जिसपे आपको वो शेयर खरीदना पड़ता है
Right.
अगर आप चाहें. So an ESOP is simply the option or the choice given to the employee of a company to buy the share of the company at a predetermined price, which is the exercise price. ठीक है, तो उसमें फायदा बस ये होता है एम्प्लॉय का कि जैसे देखिए जो एक्सरसाइज प्राइस होती है दैट इज स्लाइटली लोअर देन द फेयर मार्केट वैल्यू ऑफ द शेयर. ठीक है, तो अगर 2 साल बाद वो कंपनी का शेयर अगर चल रहा है, समझ लीजिए एट 5,000 रुपीज अ शेयर, हाँ, एंड आपका एक्सरसाइज प्राइस है 4,000 रुपीज. ठीक है, तो ऊपर का जो 1,000 रुपीज है, ऑब्वियसली देयर विल बी टैक्स डिडक्शंस, देयर विल बी द स्टैट्यूटरी डिडक्शंस, वो सब जाने के बाद कटकुट के आपको कुछ प्रॉफिट उसमें से मिलेगा. दैट इज द होल पॉइंट ऑफ एन ESOP. सो ये 2 स्टेजेस होते हैं. पहला स्टेज होता है वेस्टिंग पीरियड, जिसमें जो मिनिमम टाइम है which the company I'm sorry the employee must stay in the employment of the company to get an option to exercise the ESOP. ठीक है, तो समझ लीजिए ये 2 साल आपने बिता लिए एम्प्लॉय ने, उसके बाद उसको ऑप्शन मिलता है वो ESOP एक्सरसाइज करने का. मतलब क्या कि वो जो शेयर है जो आपको बोला गया था कि सर आप ये 4,000 रुपए में खरीद सकते हैं, तो आपको पहले वो 4,000 रुपए में खरीदना पड़ता है, तब जाके वो आपके पास आता है एज अ फ्री होल्ड शेयर, एंड देन यू कैन सेल इट एट द फेयर मार्केट वैल्यू. उसमें भी ट्रांसफर रिस्ट्रिक्शंस होते हैं. इन अ प्राइवेट लिमिटेड कंपनी एंटायरली कंपनी के हाथ में होता है. टिपिकली कंपनी बोलती है कि आप हमें ही बेच दो. हम आपको देखो आपको 5,000 रुपए मिलने से मतलब है ना, हम देने को तैयार है, आप हमें ही बेच दो. राइट, आपको उस 1,000 रुपए के प्रॉफिट में मतलब है. ऑब्वियसली पोस्ट टैक्स डिडक्शन वो जितना भी 30% वगैरह कटकुट के 700 रुपए जो आ रहा है उसमें आपको इंटरेस्ट है. अब परक्विजिट भी कटेगा बाय द वे. ठीक है, तो ये सब कटने के बाद जो प्रॉफिट आएगा, द एम्प्लॉय इज सिंपली इंटरेस्टेड इन दैट प्रॉफिट. आई डोंट थिंक ही इज इंटरेस्टेड इन होल्डिंग दैट शेयर. या ही माइट बी इंटरेस्टेड इन होल्डिंग दैट शेयर, सो ही कैन चूज नॉट टू सेल इट फर्दर, कि आप एक्सरसाइज करके अपने पास रख लो इस उम्मीद में कि हाँ भाई ये ना और 2 साल बाद 10,000 रुपए का हो जाएगा, मैं तब बेचूंगा. ठीक है, सो ESOP इज नॉट एन स्वेट इक्विटी. स्वेट इक्विटी में आपको डायरेक्टली शेयर्स अलॉट होते हैं एट फेस वैल्यू, टिपिकली एट फेस वैल्यू 10 रुपए होता है, विच इज सिंपली अ नॉमिनल अमाउंट. ESOP में आपको पहले वो खरीदने पड़ते हैं एट द एक्सरसाइज प्राइस. बहुत जमीन आसमान का फर्क है. I hope the concept is clear now.
Yes, sir. Yes, sir.
Right? Yes. Yeah. Any other question?
Hello, sir. My question is, like I have recruited some employee, and he's not. He's given work from home, and he's not working seriously. Means he's just working 2 or 3 hours in place of.
But sir, how do you measure that?
That is the issue, na, sir. How we can measure?
Correct. So, see, that
based on their output, I can guess. Based on their output and attention, we can guess he's working.
Correct. But then, have you communicated your KPIs clearly in writing to him, saying that okay, for example, अगर कोडिंग है, ठीक है, he is a coder, ठीक है, तो आपने क्या ये मेंशन किया हुआ है कि भाई आपको see टिपिकली नॉर्मली एम्प्लॉयमेंट एग्रीमेंट में ये इतना तो लिखा रहता है कि आपको जो टास्क दिए जाएंगे वो आपको करने पड़ेंगे. इफ यू फेल टू परफॉर्म एज पर द रिक्वायरमेंट्स ऑफ द कंपनी may terminate you by giving you a notice of 30 days, 15 days, whatever it is. Right?
Yes, sir.
So
that clause is there. But
so simple है sir. If you're not happy with that employee, simply give him a notice and we'll terminate him.
Thank you, sir.
Yeah. अच्छा, इसमें एम्प्लॉय टर्मिनेशन में this is also something that you can इंक्लूड, और ये फाउंडर्स के एग्जिट में भी होता है. देयर समथिंग कॉल्ड गुड एग्जिट एंड अ बैड एग्जिट. ठीक है, फाउंडर्स एग्जिट में. फाउंडर्स एग्जिट में गुड एग्जिट मतलब वो होता है कि म्यूचुअली एग्री करके कि ऑन एमिकेबल टर्म्स इफ अ फाउंडर इज एग्जिटिंग द स्टार्टअप, तो उसको अलग सहूलियत मिलती है. जैसे फॉर एग्जांपल अगर वेस्टेड शेयर्स हैं, ठीक है, तो वो उसके पास ही रहेंगे. ही विल रिटेन ओनरशिप ऑफ वेस्टेड शेयर्स. हाँ, बैड एग्जिट अगर होता है, बैड एग्जिट क्या होता है कि भाई इफ ही इज फाउंड एंगेजिंग इन फ्रॉड और cheating or non-performance, right? Any of these things, and he is asked to exit. हाँ, तो इन दैट केस ये भी हो सकता है कि उसके जो वेस्टेड शेयर्स हैं वो भी वापस लिए जाएंगे. द कंपनी विल बाय बैक द वेस्टेड शेयर्स एट अ फेस वैल्यू व्हिच इज 10 रुपया.
Yes, sir.
ठीक है. सिमिलरली एक एम्प्लॉय के इसमें गुड एग्जिट या बैड एग्जिट का भी क्लॉज हो सकता है. तो अगर बैड एग्जिट है, which means that if the employee is terminated for non-performance or breach of contract or breach of non-confidentiality or any other provisions of the employment agreement, breach of those provisions or carelessness, negligence, XYZ, तो आप ये आपके एम्प्लॉयमेंट एग्रीमेंट में कर सकते हैं कि दैट वी विल टर्मिनेट यू विद अ शॉर्टर नोटिस ऑफ जस्ट 7 days probably, and you will not get any compensation in lieu thereof. तो इसमें अगर आपको ये करना है, ठीक है, तो फर्स्ट थिंग यू हैव टू हैव दैट प्रोविजन right at the beginning when you are signing your employment contract. Number one. Number two, you will have to have enough written evidence of such negligence or fraud or cheating or non-performance. तभी, वरना अगर वो लेबर कोर्ट में चला गया ये बोल के कि सर ये वैसे तो मेरा 2 महीने का नोटिस पीरियड है और ये अगर मेरे को जल्दी निकाल देते तो इन्होंने मुझे 1 महीने का सैलरी देना है, लेकिन ये मेरे को सैलरी देना नहीं चाहते थे, इसीलिए इन्होंने नॉन परफॉर्मेंस का झूठा बहाना मार के मुझे 1 हफ्ते में निकाल दिया विदाउट कॉम्पेंसेशन. देखिए, अंडरस्टैंड, लेबर कोर्ट्स आर नेचुरली इन फेवर ऑफ एम्प्लॉइज. ओके, तो वो देयर इज अ नेचुरल बायस ऑफ लेबर कोर्ट्स टुवर्ड्स एम्प्लॉइज. तो इसमें स्टार्टअप्स को धक्का लग सकता है. ठीक है, तो ऑलवेज मेक श्योर कि टू मेक श्योर ऑफ द परफॉर्मेंस ऑफ योर एम्प्लॉइज, you document everything. If he is not showing performance, he is not doing that, make sure you write regular emails to him saying that it has been observed that you are not working so and so, you are not completing your targets, blah blah, or you are not meeting your deadlines, kindly explain.
Right, sir.
ऐसे करके you build that chain of evidence. ऐसे 4 नोटिसेस उसको भेजिए. मैं झूठा नहीं बोल रहा हूँ, मैं ये नहीं बोल रहा हूँ कि जबरदस्ती का आप ये करके किसी को भगा दीजिए. आई एम नॉट सेइंग दैट. आई एम जस्ट सेइंग दैट इफ यू वांट टू रियली बिल्ड अ केस, मेक श्योर दैट एवरीथिंग इज इन राइटिंग.
Right, sir. And sir, suppose his work, some of his work like graphic design or some make things which are the intellectual property of the our company, and he want to he can sell out after that termination. उन्होंने terminate कर दिया 1 महीने के अंदर, तो वो sell करना चाहेगा, तो हम कहाँ जा सकते हैं? In which court we can go or what we can take action?
So first of all,
we have agreement. We have that mentioned in the letter agreement during this
okay.
time.
तो देखिए सर, कैसा है लीगल, तो चीजें होती रहेंगी. मतलब you can send him a legal notice saying that you have been found to breach our intellectual property, protection of intellectual property clause or a confidentiality and non-disclosure clause of the agreement, ये वो सब वगैरह. ठीक है, एंड उसके कुछ आप डैमेजेस मांग सकते हैं उससे. ठीक है, फॉर एग्जाम्पल अगर आप उसमें लिख देते हैं आपके एग्रीमेंट में ही कि इफ एन एम्प्लॉय इज फाउंड एंगेजिंग इन एनी ऑफ द एक्टिविटीज, the company shall he'll be liable to pay liquidated damages of rupees 10 lakh to the company, for example. ठीक है, तो वो हो जाएगा. अगर आप अमाउंट स्पेसिफाई नहीं कर सकते हैं या नहीं करना चाहते हैं, ठीक है, तो यू कैन ऑलवेज क्लेम डैमेजेस. बट व्हाट आई विल से इज दैट ये तो ठीक है, लीगल मेजर, ये हमारे जैसे लोग बैठे हुए लीगल नोटिस भेजने के लिए. बट व्हाई डू यू वांट टू गो दैट रूट? आई एम सेइंग, व्हाई डोंट यू हैव सिस्टम्स इन प्लेस which monitoring systems, IT security systems in place which make it very very difficult or almost impossible for your employees to take away or carry away or transfer any of your material, तो आप emails जो हैं उसको ये कर दीजिए, restrict कर दीजिए. ऐसी all these systems are available in the market, right? Which can prevent, जो USB ports हैं उसको block कर दीजिए, restrict the usage of the LAN or Wi-Fi. Laptops उनको घर पे ही रखने को बोल दीजिए. I mean, whatever it is, So you must have a very robust IT security policy in place to make sure कि ये इतना मुश्किल आप कर दें उसको कि वो ये कर ही ना पाए. And बाकी अगर कुछ होता ही है despite contractual provisions, तो lawyers like me are there at your disposal to send a legal notice and enforce.
Okay, sir. My last question, like someone, I have a one. If I have a co-founder and he's working with us on based of the suite share, means he's not invested anything, any money, but he's investing his time and the intellectual. So we have given him a suite share and on certain commitment. But after a few months, he's not able to make complete the commitment, or he's not so much serious. So then how we can get them separate? How can tackle that?
So again, you have to have that agreement in place which specifies all these things, that he'll work for you for a minimum period of two years and deliver to the satisfaction of the company. जो भी आप उसके deliverables होंगे वो, only then he'll be eligible for that sweat equity. If he fails to meet those standards of delivery or whatever it is, the company shall exercise the right to terminate his employment without any compensation. Or you can, to be fair, see, I believe in being very fair. तो आप उसको इतना बोल सकते हैं कि ठीक है, I mean, he was not taking any remuneration from you in expectation of sweat equity, right? या कोई remuneration लेता होगा, कम लेता होगा than industry standard. तो आप उसमें आप ऐसे लिख दीजिए कि भाई, अगर इसमें भी good exit, bad exit हो सकता है कि आप काम अच्छा कर रहे हैं लेकिन आपको कुछ और बेटर अपॉर्चुनिटी मिल गई, आपने बोला कि नहीं सर मेरे को निकलना है, ठीक है, एंड ऑन म्यूचुअली अमिकेबल टर्म्स वो निकल गया, ठीक है, तो देन यू कैन गिव हिम सम कॉम्पेंसेटरी अमाउंट. अगर बैड एग्जिट होता है कि लाइक यू सेड कि परफॉर्म नहीं कर रहा है, ये नहीं कर रहा है, वो कर रहा है, आप उसको लिख दीजिए कि यू विल बी I mean your employment will be terminated without any compensation. लेकिन ये पहले ही होना चाहिए सर, ये एग्रीमेंट उसके उसको एम्प्लॉय करने से पहले ही इन प्लेस होना चाहिए, तब जाके आप ये सब कर सकते हैं, उसको निकालना ये वो सब.
Sir, I want to ask a question regarding trademarks.
Yes.
सर जैसे फॉर एग्जांपल रिलायंस एक ब्रांड है, तो रिलायंस इज ए ट्रेडमार्क या फिर रिलायंस इंडस्ट्रीज पेट्रोलियम सबका अलग अलग ट्रेडमार्क होता है?
नहीं, सो इफ यू सी रिलायंस ये एक कॉमन ये सो देयर आर दीज ग्रुप मार्क्स आल्सो, ठीक है, कलेक्टिव मार्क्स बोलते हैं उनको. तो कलेक्टिव मार्क्स वही होते हैं कि जैसे आपने बोला कि एक रिलायंस कॉमन है और उसके अंदर 100 अलग अलग कंपनियां हैं
जी, ठीक
है, तो ये सबका एक कलेक्टिव मार्क होता है जो एंड दे विल हैव द रिलायंस का लोगो, वो तो सबको कॉमन है, वो तो अलग नहीं है किसी का, राइट? तो अनलेस दे हैव समथिंग कंप्लीटली डिफरेंट लाइक अ जियो, हाँ जी, तो वो अलग है, या फिर वो और कुछ उनका होगा जो which is completely different, which does not even have the name Reliance, हाँ, तो then that will have a different trademark. Otherwise वो collective marks होते हैं या group marks, I mean one of them they are called.
सर तो ये मतलब जैसे ट्रेडमार्क लेने का एक प्रोसेस होता है, वैसे ये कलेक्टिव मार्क्स लेने का अलग वो रहता है क्या?
यस.
ओके ओके
सर,
ठीक है
सर, can I ask one question?
Yes please.
See, we have a company called our startup is Hean Health Solutions Private Limited. We have a logo of Hean Health, and we have a product where product name is Dilasa. So we should have 2 trademarks.
Yes.
Or one logo and one trademark, or what would be like?
See, your logo and your name Hean Health can be combined together to make one mark, and your product name Dilasa can have a separate trademark or should have a separate trademark.
Okay, but Dilasa, it's a combination of web server app plus hardware plus some electronic device. So whether it should be listed in 3 different categories or it will be considered only as a medical device.
Yeah, so I would suggest that, I mean, you at least see the sum total of it is a medical device, right?
Yes.
Then you should register it under the medical device.
Okay.
That will also give you a very broad protection.
Okay. Thank you.
Yeah. All right, then I think we are a little short on time. I have other, urgent commitments also. So we'll stop here. Anyone who wants to, get any other query clarified, Uday Bhai has already, shared my mail ID over here in the chat box. Just for everybody's convenience, I'll just put it again. Here it is, right? So you can get in touch with me, or Uday Bhai, he can forward your queries to me as and how you deem appropriate. Okay,
Yeah.
and it was a pleasure, being here. I hope this was helpful to a lot of you, or all of you, or some of you at least. Was this helpful? Can I have yeses or nos in the chat box? Was this helpful? Was this session helpful? Did it really add value? Perfect. So, Sonali is saying it was helpful. Thanks a lot,
Yes,
Sonali.
definitely.
All right.
Thank you so much, sir, for the in detail the concept for the legal mistakes that startups should avoid earlier. And they don't have to much the compliances. They don't have to face much more compliances in their own startup journey.
Absolutely.
This is very much helpful that any startup should have think on this particular topic, so that they can avoid particular mistakes and save multiple time as well as money and their own own innovation also. So thank you participant for engageful interaction with our guest speaker Hemant Kelkar sir. He is also our startup legal is also a partner as an legal a corporate partner of ASC Pinnacle. We are also associated with different services as a reasonable costs, where any startups can get in touch with us as well as Hemant sir. That will be very negotiable cost for anything that you guys need. So thank you so much, participants. Thank you so much, sir, for the time and the valuable information and inputs and knowledge sharing session. Thank you so much.
Thanks a lot. Thanks a lot, Uday.
Yeah. So we are winding up here. Thank you so much, participants, for your time and the efforts. Thank you so much.
Thank you. Yes.